he's talking about state, federal, international coordination, or sometimes competition. Until recently, I was at the Department of Justice as Assistant Chief of the Expert Analysis Group at the Antitrust Division, and this was something that we saw consistently across cases. It often makes headlines with larger cases, but it's consistent even with much smaller deals where there are more local effects, that we have interactions with state enforcers for the most part. And we have a really great panel to talk about this. So Eleanor Hoffman, as just said, bureau chief here in New York, and Roger Alford, my prior colleague, who's at the law school of Notre Dame today, but has been principal DAG and also DAG in charge of international affairs at the Antitrust Division. And in addition to his current role, Pier Antonio has been with the EC's competition authority as well. So I don't want to go into a long introduction because I think they have a lot of really interesting things to say about this. So let me start with what is perhaps the most obvious question that I could ask, which is, in the past year, have you noticed any, meaningful changes in the coordination between the different levels of enforcers, particularly with the change in administration, and if so, what do those look like? And I'm going to pick on Roger first to start us off.
Thank you. And so for those who don't know me, I was at the Department of Justice from March until the end of July on leave of absence from Notre Dame. And then I left under difficult circumstances, I guess to use a euphemism, because of opposition between the Antitrust Division on the settlement regarding HB, Juniper merger, and people that were senior to the Antitrust Division. And so ever since then, I've been occasionally speaking out to address the concerns arising from that. So I would say the most obvious difference between the European enforcement and the United States enforcement is both in the first Trump administration and the Biden administration, there was a lot of support and complementarity, I think, with respect to the enforcement. The EU was way ahead of the United States in terms of enforcement of big tech cases. In fact, we were in the Trump administration first time, we were criticized routinely for where are you guys? You guys are so far ahead of us. And we were just thinking about what to do with big tech problems in the United States. And of course, as you all know, it wasn't until 2020 in the fall that we finally did start bringing cases. Facebook with the FTC and then Google with the DOJ. The Biden administration, I think, was very cooperative toward Europe as well. And the relationship, I think, was very strong. And it's quite notable that now, this past year, it's strong hostility by the Trump administration with respect to European efforts to rein in big tech, both under traditional competition law enforcement and under the DMA. And I think the big tech lobby is basically working hand in glove with the Trump administration to try to tamp down any efforts by the European authorities to basically deal with competition enforcement. That, to me, would be the most notable change. I could say things about state AG, but I'll maybe preach over for Eleanor to talk about that.
Okay.
So, with regard to the relationship between the state AG offices, I should first remember to make a disclaimer. Anything I say here today reflects my own opinions only, and not necessarily the opinions of the AG of the state of New York, Letitia James, or anyone in her office. So, with that in mind, with regard to the relationship between the state AGs and the federal agencies, the first thing I have to report is continuity. So we continue to work very, very closely with the excellent antitrust lawyers at the DOJ and the FTC at a staff level. This has been obvious, our continuing cooperation after the new administration took office on the Google search case, on the Google ad tech case, on the Live Nation case, which there's a trial scheduled to begin there on March 2nd in the Southern District of New York. That is a project where we've been cooperating very, very closely with the DOJ trial team. We recently brought a case in the Eastern District of Virginia against Zillow and Redfin, which involved an agreement, in our view, not to compete. And that was in conjunction with the FTC. The FTC brought a parallel lawsuit the same day as we did. So that's the good side of it. There are situations where we have differed with the Justice Department or the FTC in particular matters. I do want to make the point that historically and to this day, we're very much aligned in how we view a case or how we litigate a case and how we resolve a case. On most cases, I think 98.9% probably. But there are differences. So most recently, you heard Roger mention the HP Juniper merger. So in that case, the DOJ investigated a big national merger between HP and Juniper. They filed a complaint during the beginning of the Trump administration. The complaint alleged that the merger would be anti-competitive and a violation of Section 7 of the Clayton Act, really focused on a market called WLAN, wireless local area networks for large enterprises. The states did not investigate the merger. We have limited resources. We have to be very selective about what we want to devote our resources to. The DOJ litigated the case and was ready for trial. And then 10 days before the trial date, they settled. That came as a surprise to, I think, most everybody who follows antitrust news. And the case was trial ready. And they settled. So after the case settled, Roger and another highly placed official at the DOJ left. The reports were they were asked to leave for insubordination. And there were public statements made by Roger and rumors in the press that perhaps the settlement wasn't directed at the principal or wasn't motivated by the principal issues raised in the DOJ complaint. The states read all this. We became concerned. We looked at the settlement documents. We looked at the complaint. The settlement didn't seem to address the main issues raised in the complaint. And so in the context of the Tunney Act proceeding, which is a proceeding the DOJ has to file for court approval of these settlements, the states, a number of states submitted comments, which and the DOJ is obligated to address the comments that are submitted by the public in the context of the Tunney Act proceeding. We then also filed a motion to intervene. And the gist of both the comments and the motion to intervene was, we're concerned. You know, there may be an issue here we don't know enough. And we asked the court to take a careful look at the settlement, because in the Tunney Act context, most settlements are approved. There's usually not a lot of controversy. But in this case, we said there's enough here so the court should hold a hearing, should do some discovery, and we intervened for the purpose of assisting the court, engaging in discovery, and bringing some facts to light. It may be that the settlement is perfectly adequate and in the public interest, which is the court's charge in a Tunney Act proceeding, and it may not be. So in an unprecedented decision, the court granted our motion to intervene, and we are now on a very fast-track discovery process. The court has scheduled a hearing for March 23rd and has not yet decided whether it will be an evidentiary hearing at which we and the DOJ and HPE will be able to call witnesses. So that's where things stand right now.
So in a slightly different direction, you know, as an economist, there are sometimes reasons why the states and the federal enforcers might see things differently, that the market that you might be looking at in a particular state could differ. So there may be substantive reasons, and is that also the case for differences in the law between federal enforcement and state enforcers?
I would say for the most part, federal and state enforcers are very much aligned on legal theories in any particular case. Where there might be a difference could be on the remedies side. For example, in a merger that involves a lot of local markets, a retail merger, we may have a concern about a particular locality, and the DOJ may not have that concern. We may seek divestiture in that particular locality that the DOJ wasn't focused on, and that has happened in the past.
The other thing that's interesting about the state strategy versus the federal strategy on these cases, I worked for Texas AG's office for 5 years on the Google case as well, so I'm very familiar with state enforcement. Super impressed with the coordination that happened across the state AGs on that case. And what's remarkable, to me, just shocking, is that state AGs will bring antitrust and consumer protection cases together and have multiple causes of action and increase the leverage that they have over the defendants because of the fact that they do that. And the DOJ doesn't really do consumer protection, and the FTC does do consumer protection, but they rarely bring a complaint that includes both consumer protection and antitrust enforcement. And to me, it's a huge advantage to have both, because you have the leverage of 10,000 per violations in the case of Google Ad Tech, which quite literally goes into the trillions of dollars in violations. The real cap on violations is not the statute, but the excessive fines provisions of the US Constitution. And to me, there's just a lot of opportunity for the states to be more creative because of the fact that the way they combine the different causes of action in some of these cases.
I'd like to turn to Pier Antonio now to look at the more international view, both of changes in coordination in the last year, and also to this interesting question about how remedies could drive differences.
Yeah, of course. And again, I start with the usual disclaimer that my views are personal. I do not reflect the ones of the organization I work for. And the cooperation between the EU and US authorities dates back decades. And we need to make a distinction between federal. I'll give a brief overview of the framework and then of the practical experience. The framework differs between state and the federal level. With the federal level, we have a cooperation agreement dating back from 1991. And that basically sets the procedural framework, or the structural framework for our cooperation. And basically the parties that are the European Commission, so DG Comp in particular, and the US and FTC. On the US side is the FTC and the DOJ. And the parties commit to keep each other informed of investigation that can have an impact on the other markets. They can exchange information. They regularly meet. And so this is basically the framework for our long-standing cooperation with the federal authorities. We do that both for merger cases and for big international mergers. This is most often the case that we interact with the FTC and DOJ, but also for conduct and cartel cases. We have basically done a joint down raid and subpoena, coordinated down raid and subpoena in 2023 in March, and again in October. In March we did it for for fragrance producers, and this resulted in coordinated down raids in the UK, in the US, Switzerland, and subpoenas in the US. Also, the communication was aligned, so we jointly received released a joint video, and we have seen also practical effects on the ground, because the business community has picked up that we are cooperating more closely, and so it's no wonder that the leniency applications also start coming in more and more. As to the cooperation in the last year with the US administration, we have seen continuity rather than rupture. And again, the divergence makes more headlines, but as I say, our cooperation at technical level stays strong, and we keep cooperating, and it doesn't make news. And in my personal word, I as Peggy was saying, I'm based in DC, and I am responsible for the contacts between the two sides, and when I don't hear anything, it's good news. So it's it's reassuring that they don't call me. So that's for the federal side. On the state AG side, we also have cooperation dating back decades since the Microsoft case. And in that case, we don't have a structured agreement in place, but that doesn't mean that we don't have cooperation. To the contrary, we cooperate with most state AGs. We can only exchange non-confidential information in the case unless the parties...
That's the big difference.
Yeah. Unless the parties give us waivers, but we still see a lot of values in exchanging views about the way you see the market, or how could you, I don't know, assess a specific theory of harm or design a remedy. So there is a strong cooperation. And what we saw is an increased role of state AGs in antitrust enforcement in recent years. And experts say that we probably expect more and more in the coming years, and so we expect also on our side to cooperate more and more with state AGs. And I mean, let's also not forget the other authorities around the world, because it can be also a multilateral cooperation, and so there are fora like the OECD or the ICN, where both the EU and US have been active participants, and the discussions at policy level can definitely help in making also the convergence on the substantive issues which arise then in practical cases. It can kind of lay the ground for kind of an easier conversation, or where everybody understands where the other is coming from. So also on that, we have seen continuity, because Assistant Attorney General Slater is now chair of the Working Group 3 of the OECD, so Enforcement and Cooperation, and they regularly attend the ICN and OECD meetings. So again, we see more continuity than anything else.
The only thing I can add to that is that the remedies in Europe are very often quite different than the remedies in the United States. That's I think that's the most notable difference. That you have, very large fines that can be imposed, like in the billions of dollars. In the United States, federal enforcers rarely do fines. They can do damages if they are a victim of the antitrust abuse, but typically it's injunctive relief. But the injunctive relief often comes in the shape of behavioral remedies and structural remedies, or some combination of that. And it's not common for European enforcement to lead to structural remedies. And I think it would be politically controversial for the Europeans to have structural relief of a breakup of a US big tech company, unless it did it in conjunction and coordination with the United States.
I'll just add that the state relationship, as Pier Antonio has pointed out, has been growing over the years. So we're very much in communication with DG Comp, with the national authorities like the CMA and the Bundeskartellamt, the ACC, I hope I have enough C's, that's the Australian Competition Authority, with various authorities in Latin America. And we do exchange ideas. We also stay very much on top of developments around the world. And I don't know whether Luisa De Lauro is here. She's an AAG in our office, and she has actually now headed up that project for the AGs nationally by keeping us apprised of developments, succeeding Beatriz Marquez, who's now with the OECD but used to be with our office.
So overall, I'm getting a story of the more things change, the more they stay the same over the past year. But one thing that's been discussed in Washington that perhaps could change that is if Congress were to enact the One Agency Act to consolidate federal enforcement under a single U.S. antitrust agency. And would that possibly change any of this state or international coordination? And if so, how might that matter?
It's a purely hypothetical question.
Clearly.
It will never.
I'm an economist. I'm sorry.
It will never happen. It will never happen. It's been introduced numerous times. It would require 60 votes in the Senate. And in addition to that, the FTC is subject to oversight by a different agency within Congress. And so Congress committee doesn't want to give that up to Judiciary Committee. So there's a whole variety of reasons why it wouldn't work, but it's not going to happen. It would make a big difference, though. And what could happen would be a voluntary, what could happen is a voluntary willingness to act as if the One Agency Act were effective at the order or request of the White House. Imagine a scenario where you have an FTC that's truly committed to the idea of unitary executive. Mm-hmm. And Andrew Ferguson has said, I work at the orders of the president. So if the White House wanted to say, basically, we're going to effectively act as if we have a One Agency Act, and we're going to subsume the FTC's decision-making under the White House or under some special committee or under the DOJ, then that would be a really radical change. And there's nothing that politically that would prevent that from happening, and especially with clearance agreements. One of the biggest fights that we have between FTC and DOJ are clearance fights. And if there was just an agreement that ultimately the Attorney General and her delegated authority gets to resolve the clearance fights, then that actually would be pretty significant.
Well, skipping over the hypothetical then, all of this brings us to a somewhat of a thorny issue, which is the multiple authorities that have jurisdiction in antitrust, and how this isn't just about coordination. This is also about how concurrent authorities have their own risks, correct? And so we can have inconsistent theories of harm, different remedies. I'd really like to dig in a bit more into how that plays out, and what that means for parties that are navigating multi-jurisdictional authorities. So I'm gonna pick on Roger again to start. And do you find in general that state AGs align, and do they pursue distinct theories, or I think you said earlier that they're 98% of the time, give or take, they're on the same page?
I think there's alignment most of the time. I think that very often there will be issues that are more regional or state in focus, and then we would politely defer to the states to handle that one because they have scarce resources. The federal enforcers have scarce resources. So that's a relatively easy question. And I saw that. We saw situations where oh, that would be a great one to tackle, but it's sort of localized. So, yeah. And then I would say that there are instances in which there are scarce resources, and we would love it if they would take the lead on it, because we just don't have the resources to do it. We think it's an important case, but because it's sort of localized, we don't mind being on the case. Overwhelmingly, the feds want to be first chair, overwhelmingly, right? But there are occasionally times when they're I wouldn't mind being second chair on this one because it's kind of localized. I think the ad tech case was the most interesting case of coordination.
Sure.
Where what really happened was the DOJ, Trump administration wanted to bring a search case, and they ran out of time to do an ad tech case. Biden administration did an ad tech case a couple years later. In the meantime, a coalition of states across the political spectrum wanted to do cases as well. New York overwhelmingly took the lead on the Facebook case, but on the Google case, Colorado and Nebraska wanted to take the lead on some of the Google cases, and Texas wanted to take the lead on some others. So they sort of divided and conquered, basically, and the vertical abuses were led by Colorado and Nebraska and then subsumed into the Google search case. And then Texas ran its own ad tech case 2 years ahead of the Biden administration's Google ad tech case. But what really happened in the ad tech case, and especially the search case, was literally argued together, right? The Colorado counsel argued with the DOJ counsel, and my impression was obviously there were frictions about timing and debates and who raises what issues, and there were different causes of action. The vertical claims that Colorado brought were different than the DOJ claims. But I think that was because of the decision, well, we'll give you this space to run with, and then we're going to run with this. So that, I would say mostly a lot of coordination, but it is true that states don't like it when the feds always want to be first chair, and I understand that, and so that's a difficulty when there is, working same cases. You probably, Eleanor, can speak
Right.
to that.
Do you concur as, our state
So-
representative?
Yeah, so I'll just add a couple of things. One is, yes, there are, in any group, right? In a family, you got to work out your differences. In the Google search case, there were two parallel complaints. The states raised some claims that the DOJ did not raise. A lot of our claims were overlapping. I think our complaint actually incorporated the DOJ's complaint specifically, but the team worked very well and worked out their differences. The states did have a significant role in the case.
And argued well. I mean, the arguments were great.
Yeah, and one of the AGs in my office, Mike Schwartz, pretty much ran the state team during the remedies case. So, they worked out their theories of harm and what remedies we wanted together with the DOJ. So it all worked out, I think, well. One interesting aspect of state-federal litigation is the complementary nature of state law. So, for example, in the case we brought against a company called Viera and the president of that company, Martin Shkreli, a few years ago, involving a series of restrictive agreements designed to keep generic competition off the market for a drug called Daraprim. The FTC and we and a few other states brought that case. New York had actually started the investigation. The FTC came on board later on. And we tried the case together. But during the pretrial period, the FTC originally had asked for nationwide disgorgement. And then the Supreme Court told the FTC that they did not have authority to seek disgorgement in a decision called AMG. But the states had disgorgement authority under their various state laws. And New York's law is especially well developed in this area. And we litigated, we won on liability, and we also obtained a ruling that there would be nationwide disgorgement of all profits earned by this company, which happened to be located in New York. So,
Can I add one other comment? There's a big development since 2022 that's really notable, and it's going to change the strategic equations for state AGs. And that is that when the federal government brings an antitrust case, they can decide where they want to go and they can stay there. When the state AGs want to bring a case, they can choose to start a case somewhere separate and apart from the federal government, but because there's so many private litigants that will piggyback the litigation, there's a statute called the Multi-District Litigation Statute, an MDL statute, and then it consolidates all those private cases into a specific location, 25, 50 cases all in one place. And the states were always sort of just forced into that arrangement against their will. It was definitely a shotgun wedding where they didn't want to be there, but they were there. And it was especially frustrating because the states started the cases and then these privates piggybacked and copied the cases, and then you had to go wherever the MDL was. So we were upset with that. All of us were upset with that. 52 state AGs signed a letter opposing